The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain how Illinois child support works with respect to extraordinary medical expenses, special needs, educational expenses, extracurricular expenses, and child care expenses. So we have a lot of great articles and videos about child support at learn-about-law.com, so check those out for some foundation on how child support works. But the quick and dirty version is that child support is calculated in Illinois based on coming up with a number that the parents together owe for the well-being of the child that they have to together contribute, and this is based on economic tables, certain guidelines that the court uses to say in these economic circumstances with this many children, we expect the parents to together contribute X amount. Now, how much the obligor is required to pay is based on the incomes of the parents relative to one another. So each parent's share of that amount that they have to pay is based on how much they make in net income relative to each other. So that's how child support works. But it works a little bit differently with medical expenses that are extraordinary and unusual, as well as special needs. And we'll talk about the other additional expenses later. But courts are permitted to deviate from the guidelines whenever they think that following the guidelines would either be inequitable or inappropriate. If they want to deviate from the guidelines, they have to include in the order that they write up their reasoning for deviating from the guidelines. Now, the Marriage and Dissolution of Marriage Act provides for 3 specific reasons that courts can and should deviate from the guidelines. One is extraordinary and necessary medical expenditures for the child or either parent. That's kind of surprising that medical expenses for the parent can be included too. Additional expenses incurred based on the child's special medical, physical, or developmental needs, and any other factor that the court that would lead the court to find that application of the guidelines would be inappropriate based on the best interest of the child. So when we're talking about medical expenses and special needs, rather than ordering an additional payment on top of base child support, what the court will do is deviate from the guidelines and order a higher child support amount than the guidelines would normally anticipate. And this is a little bit different than childcare expenses, educational expenses, and extracurricular expenses. For these 3 categories of expenses, what the court will do is expect both parties to contribute, but they will order an additional payment for these on top of base child support. So the parties will have to kind of lay out what these expenses actually are, and then the court will order how much the obligor has to pay. Now, they all work basically the same way, all 3 of these types of expenses, except there's some extra caveats that the statute provides for child care expenses specifically. These are to be divided between the obligor and the obligee in the same way that basic child support is. So it's based on the relative net incomes of the parties. So if once the court gets to that total amount of child support that the parties together owe, and they decide the obligor has to pay 70% and the obligee is responsible for 30%, that's the same way that child care expenses will be divided. Child care expenses are defined as actual expenses reasonably necessary to enable a parent to be employed, to attend educational or vocational training programs, to improve employment opportunities, or to search for employment. So that's when child care is appropriate and allowed, and additional payments will be made for it. The amount the amount the obligor pays is based on actual expenses, so it's not an estimate. And if actual expenses tend to vary from month to month, then the court will use a 12-month average of those actual expenses. And if the actual expenses change, then the person receiving child support is responsible for giving notice 14 days in advance to the obligor so that the obligor can go into court to change the amount of child support they're paying. The amount of additional amounts on top of child support they're paying for these child care expenses. So the bottom line is that for all of these different categories of expenses, child care, school, extracurricular, medical, and special needs, you will get something on top of normal child support ordered by the court, except that medical expenses and special needs are a deviation upward from the guidelines, and it's basically the basic child support is just increased. For the other categories of expenses, there's an additional payment typically that is made in addition to the base child support, and sometimes it's combined, but that's how it's treated according to the statute. So if you have any questions, you can leave them below this post at learn-about-law.com, and we'll try to get you an answer within a couple days. If you found this interesting and would like to be informed of our daily article and video topics that we're putting out, you can subscribe to us on YouTube, iTunes, and SoundCloud, or subscribe to our email blast. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.